I do apologise. I was intending to ask if we could have the clock sorted out over the shorter German, and then I forgot.
Oh,
So
it has
It's been done.
It has been, Malene.
oh, it had.
The staff have given us a new clock here, just in front. You can't see it yourself. We know the time.
Thank you very much.
Thank you.
So before the
Mr. East.
So before the shorter German, I said I was going to kick off with the law in relation to section 231B. The words of the statute themselves are at page 2 of the authorities bundle, tab 1. And the point has been made perhaps already that where it says a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing, signed by some person who is able to declare such trust. That is not a requirement that the declaration of trust itself be set out in the signed writing. And I think that point was accepted by learned friend. But it's a point which, in any event, is established by the recent Court of Appeal decision in the National Iranian Oil Company case, which I'm happy to go to, so your attention, your lordships, can see that. So that's page 623 of the authorities bundle. And it should be, that should take on to paragraph 144 of Lord Justice Zakharoli's judgment.
I'm sorry, paragraph.
Paragraph 144.
Thank you.
It's in 145 that that point is held. So, so this is a case. It's quite a complex case in terms of the facts, but it's a case which focused on questions such as whether Section 53(1)(b) could be satisfied by signed writing by an agent for the sector, which is not an issue we have here, but also what the status is of a trust which cannot be proved by the requisite writing. That was the ground 3 in this, ground 3 of the grounds of appeal in this case. It should be said that the Court of Appeal, as I understand it, gave permission to appeal itself to the Supreme Court in that case. But paragraph 145, there's a reference there to the case of Forster and Hale, which I intend to take before to due course. And a passage there from that case, and then 145, Lord Justice Zakharoli says, this passage also answers a point made by CGC that manifested in order not to be OTOs must be read as imposing a requirement that the trust must be created in writing. That's rejected. The section has consistently been interpreted as requiring no more than that the trust must be proved by written evidence. Then paragraph 146 onwards, there's a consideration of the Rochefoucauld case. And Lord Justice Zakharoli says at the beginning of 146, that was the clear conclusion reached in Rochefoucauld, i.e. the same conclusion that you only need to prove the trust by written evidence. You don't need to create the trust in writing. Now, it's perhaps it is useful just to look briefly at 148, which quotes Rochefoucauld, the judgment of Lord Justice Lindley giving the reserve judgment of the court, where he said it's not necessary that the trust should be declared by such a writing in the first instance. It's sufficient if the trust can be proved by some writing signed by the defendant and the date of the writing is immaterial. Now, I think it's already been observed that Lord Justice Zakharoli was in the minority on some of the points in the National Iranian Oil case. But it's clear that there was agreement by Lady Justice Falk in relation to this part of the analysis. As one sees that at page 265, paragraph 265. So she's agreeing there 265, I agree with Lord Justice Zaccaroli's analysis at 143 to 145. It was 145 that we looked at, which contained the conclusion that only written evidence is required. Now, as I understand it, the points of disagreement as to the law, or the issues in relation to the law now in this case, could be summarised as follows. So, firstly, if the signed writing is not a declaration of trust itself, because of course it could be, does the court need to find that there was an earlier declaration of trust? And if so, what form does this have to take? And then secondly, what does the signed writing need to contain as to the terms of the trust? So if when one looks at the grounds of appeal in the core bundle, page 18, we see there, and this hasn't varied in the subsequent versions, we see in relation to ground 1, it said that the trial judge was wrong to conclude as an express trust in respect of the leasehold Salimi Grove. And the reasons given are 10A, the trial judge did not find that the defendant made any declaration of trust prior to 13th of October 2013. I think that should be the 12th because that was the date of the email. So the email could not have been proof of any earlier declaration of trust. B, according to its terms, it was not itself either a declaration of trust or a manifestation or proof of a declaration of trust. So the suggestion seems to be that the court, in deciding whether there is an express trust of land, needs to identify a point in time at which the trust is declared, as well as finding that there's signed writing which manifests and proves the trust. Now, the first point we'd make in relation to that is, having looked at the terms of section 53(1)(b), that is not what section 53(1)(b) says. It doesn't set out any requirement that not only do you have signed writing that manifests and proves the declaration of trust, but also the court has to be able to identify, in order for the trust to be proved, when the declaration was made. And we say, in any event, it's just simply not right on the law having regard to the National Iranian Oil case. Because if one goes to page 636 of the authority bundle, paragraph 201, it's there recited. There's no real dispute between the parties as to the relevant legal principles. The question whether a trust has been declared as an objective one, whether a reasonable person armed with the background knowledge available to NIOC would have understood that NIOC was manifesting through the mortgage loan its intention to create a trust, and Ong and Ping is then cited. Then at 205, the point is made, the question whether there's been a declaration of trust is a question of fact, reference there to the well-known authority of Paul and Constance. Unless the judge made an error in determining what constitutes in law a declaration of trust, the question on appeal is therefore whether there was sufficient evidence to justify the judge's conclusion of fact. Paragraph 214 then, one sees there the level of informality required for a trust to be declared. So reference again to Paul and Constance. In that case, the deceased set up a bank account into which he paid the proceeds of damages claimed following an injury at work. He was then living with the plaintiff as man and wife. At various times he said to the plaintiff, "This money is as much yours as mine." The Court of Appeal held this was sufficient to constitute a valid declaration of trust. Then coming on to paragraph 217, we see where Lord Justice Zaccaroli gets to. About midway down that paragraph, the fact, as confirmed by Paul and Constance, that a sufficient intention to declare a trust can be inferred from words and conduct repeated over a period of time is inconsistent with a requirement that the declaration of trust must coincide with a point in time at which there's a change in relationship.
Sorry, I'm slightly behind you. I'm so sorry. I was just looking at the passage in 214 where Lord Justice Scarman said it wasn't easy to pinpoint a specific moment of declaration.
Yes.
And then you were going on to
Sorry, I went on to 217.
Sorry.
And so just, I think it's 6 lines down, that the fact, as confirmed by Paul and Constance, that a sufficient intention to declare a trust can be inferred from words and conduct, repeated over a period of time, is inconsistent with a requirement that the declaration of trust must coincide with a point in time at which there's intended to be a change in the relationship. Then 218 is the key paragraph. So 218 says, it may, in a particular case, be necessary to pinpoint the moment that a trust arises. But that doesn't mean that no trust can be held to exist unless it's possible to point to a single occasion which constitutes the declaration of trust. Actually, the inquiry, as Onman Ping shows, is a broader one than that. Would the reasonable observer understand from a person's words and conduct that they were manifesting an intention to hold property on trust for another? And we say that those words are particularly relevant for this case, where you've got events occurring over a number of years on a very informal basis. This is a hard case to unpick because there's lots of different grounds of appeal, and Lord Justice Zacharotti is in the minority on some and not on others. But we're here in Respondents' Notice point 2a. You see that just above paragraph 200. And this was a section of the judgment where there was again agreement from Lady Justice Falk. You see that at paragraph 240. So she says, the ladyship says there, in the last sentence, however, given the disagreement between us, I confirm that I agree with Lord Justice Zacharoti's rejection of Respondents' Notice point 2a for the reasons he gives. And there's also agreement from the Chancellor, paragraph 280. So the Court of Appeal unanimous on that point. So we say, therefore, there is simply no need to identify, when proving an express trust, that a declaration of trust has occurred at any one particular time. You're looking at a much broader inquiry based on the outward manifestation of the intention of the putative trustee. Point 2, which was, well, what does the signed writing need to contain as to the terms of the trust? And the first point to make about that is the statute doesn't say anything about it. And there's no requirement that in section 53(1)b itself that the entirety of the trusts, including interests which no longer subsist, should be set out in the signed writing. But we see how the court has dealt with this in the decision of Forster and Hale. Admittedly a very old decision now, but one that, as we've seen, was referred to the National Iranian Oil case. And in particular, if I could ask the court to go to page 17 of the authority's finding, which should be the judgment of the Master of the Rolls. And so hopefully your lordships can see page 707 about midway down that page, and then afterwards there should be a sentence beginning, it was contended for the defendants that there is great danger. Shortly after the page 707. So it said there, it was contended for the defendants that there was great danger in taking a declaration of trust arising from letters loosely speaking of trust, which might or might not be actually and definitively settled between the parties, with such expressions as our and your intimating some intention of a trust, that upon such grounds the court may be called upon to execute the trust in a manner very different from that intended, and that it's absolutely necessary that it should be clear from the declaration what the nature of the trust is, or it cannot be executed. That I certainly admit. The question therefore is whether it sufficient appears to prove that Burden did admit and acknowledge himself a trustee, and whether the terms and conditions upon which he was a trustee sufficiently appear. So there are two reasons which are expressed. The first is the need to demonstrate that there's certainty of intention, I would submit, because you've got reference to trusts which may not be definitively settled between the parties. And the second is to demonstrate who the objects are so that the trusts can be properly enforced. Now, we rely on the words that it should be clear from the declaration what the nature of the trust is. To say that what must be required is for signed writing to state what the trusts then are, and that there should be no requirement for the purposes of section 53(1)b for the signed writing to reference interests which are no longer subsisting. And we submit that in relation to this, one has to have regard to the legislative purpose in relation to section 53(1)b, which has been considered by the National Iranian Oil case. So if one goes back to page 610, we will be back in that case. And the judgment of Lord Justice Zaccaroli, paragraph 78. So Lord Justice Zaccaroli there is considering see the heading of purpose of section 53(1)b. Of course, the predecessor was section 7 of the statute of frauds. And that paragraph 78, Lord Justice Zaccaroli says, so far as section 7 is concerned, the purpose was evidently to protect landowners from the risk that another person would falsely claim that land or an interest in it had been transferred to them or declared in trust for them. I see no reason why the purpose of section 53(1)b is not the same. Such changes as were made to the provision do not, in my judgment, suggest any change in its purpose. Now, this is within the judgment on ground 1 of the appeal in that case, which really related to whether it was sufficient for an agent to provide the signed writing. That is a part of the judgment in which Lord Justice Zaccaroli was not in the minority. One sees that, I think, at the beginning of Lady Justice Fulk's judgment. And you see that page, paragraph 240. I'm very grateful to Lord Justice Zaccaroli for his clear exposition and analysis of the issues. I agree with the conclusions he has reached on ground 1.
That was paragraph 240. Thank you.
So we say, having regard to the legislative purpose, which is to protect landowners from the risk that another person would falsely claim the land or an interest in it had been transferred to them or declared in trust for them, then providing that the signed writing manifests and proves the trust as at the date that it's made, that should be sufficient. That captures and satisfies the legislative purpose. There's no need to go further in our submission and for the signed writing to contain evidence of interest in the trust which are no longer subsisting. What I'd like to do now is then go on to the email correspondence itself that we relied on in support of the claim of express trust. The first email is actually in supplemental bundle at page 204, because the email, the key email of the 12th of October 2013 is actually part of a chain. And your Lordship may have been wondering about the words "as stated clearly" and why that's in 12th of October email. But one sees that actually from this prior email on the 11th of October 2013. So the email comes in the context of a family dispute between Mohammed and Shalima, the third respondent. Mohammed's perception is Shalima's financially responsible. Mohammed's angry that Shalima asked their mother Fatima for a loan. You see this email. And then you should see there's a highlighted passage about halfway down the page where he says, "I remortgaged a property which will ultimately belongs to you, Farhana and Jennifer. This was a 4-year loan under my name, but I still went ahead and did it in the hope they would help you. You have asked for an extension for 2 more years as you could not afford to pay the full amount. I had no choice to accept if the loan is in my name. Yet you had not consideration that you used someone's name to get this money. All you're concerned with is how to reduce your outgoings and maintain your lifestyle." Now, the context of that is that's a reference to £50,000 that was raised from 7 Essex Grove and provided to Shalima to help pay her debts. You see reference to that, paragraph 19 of the trial judge's judgment, although I don't think we need to go to it now. Then, when one comes on to the 12th of October email, he says, so he's upset with the response that he gets, which I don't think we actually have in the bundle. And then he says, "Whenever any of you get your act together, come and talk. Till then, I have my deadline. I want Essex Grove out of my name by 2014. This belongs to 3 sisters as stated clearly." So what we say is "as stated clearly" is a reference back to the 11th of October email where he refers to them, the 3 sisters in particular. He says, "I never wanted this property in my name." We say that is wholly inconsistent with the notion that he was the sole beneficial owner of this property. Just simply cannot make sense on that wording. I did it because no one else had the responsibility, care or inclination to deal with it. The point about the receivers, and then the work that's been done. And then he says, "So you guys have a block of flats that have at least 40 to 50% equity, not to mention a valuable home should you need it." And we say it's simply fanciful to suggest that what he's saying there is that there's any limitation on the interests which the daughters are taking. He says, "You guys have a block of flats." That couldn't be clearer in terms of saying, in combination with what he's already said, this belongs to 3 sisters, that this property is held absolutely for the 3 sisters. He goes on, he talks about maintaining mortgage payments, but then he says, "Even when it has hindered me from progressing my own interests," i.e. there's a distinction between his own interests and the interests of the sisters, but not even a thank you. And then later on, there's a paragraph beginning, but I'm comfortable that this ungrateful sister has something decent to fall back on when she actually grows up. So again, it's clear that Salima has an interest in this property. It's worth then turning to what the trial judge said about this email. So if I could ask the court to turn to page 104. And in particular, paragraph 66 of the judgment. So the email is quoted there in 65. And then at 66, she says the defendant could not adequately explain this email in cross-examination. He said that it did not make sense and had no plausible explanation of what it might mean, if not that he held the leaseholds of 706 Grove on trust for the daughters. So that's a finding of fact in terms of the intention. And then paragraph 106, page 110. Issue 3 was is an express trust manifestly proved.
You said 66 was a finding of fact. I'm not sure that's strictly right. I think 66 is precisely what the evidence was. I think the findings are in 69.
My lord, I think you're right. Other than that, I think it's a comment, really, isn't it, on his evidence, and then she comes to at 69 to actually make the final conclusion. So 110. Page 110. Issue 3 is answered there. Consider that it is the email identifies the property, the beneficiaries, and the trustee. And defendant concedes that the section can apply to a declaration made after the trust is created. So,
I'm sorry, where were you reading from?
sorry, I was looking at paragraph 107.
Thank you. I'm sorry. I've got the pages and the paragraphs mixed up. 107.
So then, looking at Mohammed's arguments on the appeal, going back to core bundle, page 18. We've got the point there made that the trial judge did not find that the defendant made any declaration of trust prior to the 13th of October 2013, so the email could not have been proof of any earlier declaration of trust. I've already dealt with that point on the law, but even looking at what the factual position is, we say this just approaches everything from totally the wrong standpoint, because what the inquiry is, if there is any requirement to find a prior declaration of trust, the inquiry is a broad one when the court is looking to see if there is such a declaration. Would the reasonable observer understand from a person's words and conduct that they were manifesting an intention to hold property on trust for another? Whether or not there's such an intention, we say, is a finding of fact. And it's simply wrong to say that the trial judge did not find that Mohammed's words and conduct manifested an intention to hold the leaseholds on trust. And you see that from the paragraph that Lord Justice Nugee just pointed to, paragraph 69. That makes the key finding of fact as to what the intention was.
I'm sorry to interrupt. Is the declaration, in a case in which you have an arrangement in 2000 that A holds on trust for B, which is manifested by A saying in an email in 2012, I hold on trust for you, is the declaration the email. In other words, you declare a trust then, even though it's an existing one, or is it that you're manifesting that there was a previous declaration? I think you say it's the latter, isn't it?
Well, so now where I think the confusion arises in relation to this is because as trust lawyers, what we often see is a declaration of trust contained in a trust deed. But
At the outset.
yeah, at the outset. But the point that's made in National Iranian Oil is that you can look to the course of conduct over even a number of years to see whether there is a declaration of trust. You don't have to point to a particular declaration of trust at any particular time. That's the point on the law that's made in National Iranian Oil.
Is it? I wondered if in National Iranian Oil, Lord Justice Sakaroli was saying, even if you have an existing unevidenced trust, the later signed writing can itself be a declaration of that pre-existing trust.
I mean, it could be. If one accepts that you can look at all the evidence put together, then certainly the email itself could amount to part of the declaration. Well, yes, because you're not looking to see. Is there a trust? Is there one moment in time where Mohammed said, "I hold this property on trust"? You're looking to course of conduct and a manifestation of outward intention over a period of time. The email could be part of that.
If someone says to someone else, if A says to B, I'm going to put this property into your name on the basis that you'll hold it on trust C, and B takes it on that basis, doesn't say, no, I want it for myself. Is that course of conduct capable of being a declaration of trust by B?
Well, we would submit yes, because it all comes in the context of a conversation where the property is being accepted on a particular basis. And so there's a good example in relation to 14 Stapleton Road in this case, albeit it's not proved by signed writing, which is Mrs. Khan said he was told it was for the three brothers, and we see that in the judgment. And if you've then got the person accepting the property, the transfer of the property on that basis, then we would say that that must manifest an outward intention to hold it on trust. I mean, it comes to, what comes to mind is what Mr. Justice Fancourt said in the Archbold case, which is, well, what would happen if he said no?
But that's a De Bruyne type trust. I'm asking about something a bit different, which is, we're really dealing in the world of express trusts here at this point.
Well, I mean, there's a similarity.
But can you spell out, sorry, if I can just ask my question, can you spell out a declaration of trust from conduct of that kind without anyone actually saying, I hereby declare a trust over this property? Because here we're dealing with the question whether the defendant declared the trust, not whether his father told him that it was going to be held on trust.
I think Forster and Hale is quite instructive on this. Yeah, and the summary in particular at 144, the National Iranian Oil case. Page 624. So So in that case, it was wide enough, 1C, just above the quote, above 145. It was wide enough for the trust to have been declared by implication from various letters, which gives you an idea of the width of the type of conduct that one is talking about.
I mean, to take my example a little bit further, and it's maybe a bit unrealistic, but on the same facts, the A says to B, look, I'm transferring this to you so that you'll hold it on trust for C, and B gives him a thumbs up.
Well,
So he hasn't said anything. But it would be very hard to say that he hasn't declared a trust in that case.
well, yes.
And if that's so, then if he doesn't say, no, I'm not taking it on those terms, it might be thought that that could be a declaration of trust.
Yes, I mean, of course, we're not in this territory in this case anyway, because if you think about Essex Grove, which is the only one where we're relying on an express trust, what we have in relation to that property is we have the email where he says this belongs to three sisters as stated clearly. So if one is consisting, if one is considering, well, what is his outward intention consistent with the declaration of trust? Well, clearly it is on the basis.
But that then raises the timing point that Lord Justice Nugee raised, because it might be said then, well, that's the point at which the trust is created, namely 2013. Whereas, as I understand the judge's decision, the trust is created right from the outset.
Yes.
But manifested by the writing in 2013.
Well, what may be helpful then is, because you're absolutely right, Lord, that the trust was created at the outset in 1998 when the property was purchased. That's always been our case. What may be helpful is to look at some of the other evidence that there was.
Sorry to interrupt. So just to be sure I've understood this. Your case is that in 1998 there was an express oral trust,
Yes, we say
which
that,
is not manifested by signed writing until 2013. When it is manifested by signed writing, that is a declaration or a confirmation, or what is it?
That's the proof that is needed under section 53(1)(b) for the court to recognise that trust as an express trust.
And it's just the proof for the purposes of 53(1)(b).
Exactly.
It isn't a declaration in itself.
Yes. Lady S.
But on the facts, in 1998, the defendant wasn't interested in the property, was he?
No,
So he comes involved in 2005, is it?
yes, so the chain
When
of
the
events,
leasehold.
the chain of events you've got, Lord, and there was an agreed chronology which may be useful in due course, which we can point you to if necessary. But the chain of events is 1998. You've got there's the sale of a property called Salford Road, a flat there by Mr. and Mrs. Carr. You've got money that's raised from that going into the purchase of Essex Grove, and it's held in the name of Fahana. Then, in 2005, shortly after Fahana's divorce concludes, so there's a mortgage on the property, which she takes on. The mortgage is discharged. 3 flats, 3 long leasehold titles are created. 2 of them are granted for no consideration. The other one is in exchange for the mortgage being then taken on by the defendant. What we say is that what happened was Fahana goes through the divorce and there's a concern on the part of Abdul and Muhammad, well, what's going to happen if, again, there's something like this and property is claimed? So the 7 Essex Grove was the subject of the divorce. It might be instructive, actually, just to look briefly at Bahana's witness statement, because it just shows how this all came about. So that's in the supplementary bundle, page 65. So she begins by saying that, referring to the transfer in 2005 to Mohammed, the initial impetus of the transfer was a divorce, 35, and there's reference there to her daughter, who was 3 years of age at the time. Due to the need to provide for her, claimed to share of the marital home, 34 Holmwood Road, as her no other place of residence. And there's reference then to the husband making a claim on the marital home. It's saying if she made a claim on the marital home, he would in exchange make a claim on 70G. Discuss this with Dan. We consider whether I transfer 70G out of my name to try and protect this family asset. The divorce concludes, and this was accepted by the defendant at trial. So the divorce concludes, and she agrees with her husband to relinquish her rights in the marital home on the basis he didn't claim against 7 Essex Grove. Despite this, Dad was still concerned about protecting 70G. And then at 41, you see Mohammed convinced Dad that it was best to put 70G in his name for this purpose. However, my understanding was that he would hold it on the same basis, that it would remain under Dad's control and Dad would benefit from it during his lifetime, then it would pass to me and my sisters in accordance with what he calls the 70G agreement. So that's the context on the facts. Not quite sure where we've shaken out with all of that, but I thought it was important for the court to understand what the factual background is to all of this. What I was going to go on to next was the point in subparagraph B of the grounds of appeal, that it said, according to its terms, it's not itself either a declaration of trust or the manifestation of proof of a declaration of trust. And the reasons given for this are at paragraph 14 of my learned friend's skeleton argument, which, and that's page 33 of the core bundle. And it said, point 1, I think this point was effectively conceded by my learned friend. It does not identify the property since it talks only of 7 Essex Grove without reference to the leasehold interest in the 3 separate flats. We of course say, well, the email refers to the block of flats. And in any event, this was the only interest in 7 Essex Grove, the 3 leasehold interests that he held. It does not declare that the property is held on trust. Well, the answer to that is quite complex for the reasons I've said, but really, the court is not looking to see whether there is a specific point in time at which the declaration of trust was declared, but this could be part of the declaration. 14.3, it doesn't manifest or prove any earlier declaration of trust. We say, well, quite simply it does, because it says this property belongs to the 3 sisters, as stated clearly in all the other sections which I drew the court's attention to. 14.4, it does not even reflect the original alleged trust over the property, reference there to Abdul's interest, to which we say, well, we accept that on the facts, but as a matter of law, that is not the requirement, we say.
I've been looking back at the bits of National Iranian that you asked us to read earlier.
Yes,
I rather think that Lord Justice Saccharelli approaches this on the basis that even if there's a pre-existing trust, the question is whether the signed writing declares a trust in the sense of acknowledging that A holds on trust for B, and that's enough. But that's not proving some earlier declaration. It's manifesting a declaration in the signed writing itself, even though it's a pre-existing trust. And I'm looking at paragraphs 20 2, where the judge says the relevant document, which is a mortgage, stated that NIOC was the legal owner and the fund its sole beneficial owner. That's what it actually stated. And the point is taken at 204, where CGC contends that NIOC already believed that ownership of the house was vested in the fund. So, and that's said to make a difference. And the Lord Justice Zakaria's conclusion is 220. NIOC was at the very least confirming that as at the date of the mortgage documents the property was held in trust, that the judge was entitled to find that suffices to establish the requisite intention for a declaration. So, looks to me as if the way he's approached it is, it doesn't matter whether there's a pre-existing trust or not, the signed writing itself by saying, this is in my name but I hold it for you, is sufficient to constitute a declaration and thereby satisfy the statute. Which is not quite the way you're putting it.
Well, it does come back to the point I made at the beginning, which was on section 53(1)(b) itself, there is no requirement for the court to find that the declaration of trust is in writing, is in signed writing. So you only need to manifest or prove the declaration of trust. That's something lesser than the trust deed that might have been out there and has been lost.
But there's a difference, and it may make a difference in this case, between saying what is proved is that Mr. Carr declared a trust in 1998, and the email simply manifests that. And saying what is proved by the email is that whatever had previously happened between 1998 and 2013, by 2013, there's an acknowledgement that the defendant is a trustee for his sisters. And they're not the same thing. And it may make a difference to one of the points, which is, do you have to say anything about the interest which has now gone? As I say, I read this as suggesting that the latter is sufficient. It may not be necessary, but it's sufficient. And that my Lord, or Justice Miles this morning, put to Justice Dumont a case where all you've got, the only evidence is, I acknowledge that I'm currently a trustee for you. Is that sufficient? And I think Lord Justice Zachary thinks that would be enough. Even if you have no evidence as to how he became a trustee or when or what the trust originally might have been.
I think this may go back to the point that I did consider the paragraph where he says, and forgive me, I've forgotten the number now, where he says, in order to establish an express trust, there is no need for the court to find that there was an earlier declaration of trust at any one particular time.
Yeah.
That's 218.
Yeah, I think so. My primary submission, Lord, is on this judgment, all that you need for the purpose of section 53(1)(b) is what section 53(1)(b) says you need. You don't actually need to have proof of the earlier oral declaration of trust. But I say that if for some reason I'm wrong about the interpretation of National Iranian Oil, we've got more than enough material to show under the Ong and Ping inquiry that there's a manifestation of intention much earlier than the 2013 email to the effect that this property should be held on trust. And I mean, I haven't taken your lordships to it, but there is a whole host of evidence in relation to that, quoted above paragraph 69 of the trial judgment, referring to, for example, the evidence of Mrs. Khan, the evidence of third-party witnesses like Mr. Udine, which suggests that which supports that this was the case all along.
I mean, I wonder whether there's another way of looking at this, which is to say, when you get something which says look, this is your property and I'm holding it for you. That's acknowledging, as Lord Justice Zaccarelli puts it in that case, that at the very least confirming, as at the date of that document, it was held on trust. That's what he says in 220. You can then look backwards and say, well, why is he acknowledging that? And nothing has happened since he got the property, the leasehold, the defendant got the leasehold interest in the property here in 2005, which would have changed the position, as it were.
Yes.
He doesn't say, oh, well, that all changed in 2010 because there was some further arrangement.
No, what he said at trial was that there was either a... He said that...
He gave a different explanation.
Yeah, so his explanation was, pre-2005, Abdul is the sole owner. Then, at that point, either there's a purchase from Abdul or there's a gift, and his case changed. So you see that actually recorded, paragraph 61 of the trial judgment. And the reason my learned friend is making all this point about dispositive control is because he has to say that Abdul is the sole beneficial owner at that point, such that Mohammed can become the sole beneficial owner in 2005. I mean, we say that's just all blown out of the water by the judge's findings of fact, and it's blown out of the water by the contents of the 2013 email. Because on any view in the 2013 email, he's saying, I hold this property on trust for the three sisters, as stated clearly. So, I mean, unless I can be of any further assistance on that ground, that's the reasons why we say that ground should be dismissed.
Thank you.
Then, so ground 2 relates to the question of whether there were adequate findings of fact or not. And essentially 2 points are made. Firstly, that the trial judge failed to make any adequate findings as to the terms of the trust in relation to 7 Essex Grove and the intentions of Abdul when establishing the trust. We say that's simply wrong, and adequate findings were made, and that a learned judge considered and rejected Mohammed's case. Linked to this, Mohammed says that the respondent's case was that Abdul intended to retain complete control over 7 Essex Grove in his lifetime, and this negatives a desire to create a trust of the property. That's what I understand it to be. And we say that that is a total mischaracterization of our position, and it runs completely contrary to the findings of fact that were made. So, if one turns to page 147, which should be the pleadings of the core bundle.
We're at paragraph 43 of a pleading.
Yes, so that's paragraph 43. So paragraph 44. It said there that, so in relation to Essex Grove, there was a common intention that freehold and leasehold trusts interest in the property held for the third to fifth defendant in equal shares, subject to Abdul having a right to income from the property and having control of it until his death. Now, so control, where all this came from was that the defendant's case was that essentially after the transfer of the properties to him, Abdul no longer had anything to do with them. And what one sees from the judgment is that that quite simply wasn't correct, and the trial judge refers to this at some points and says, well, he still maintained an active interest in them. What we were absolutely not submitting was that he retained complete dispositive control over the properties. We were very clearly pleading and submitting that there were trusts which are in place. Now, one can collect from the judgment what it is that the trial judge thought in the end was the control that was exercised. Because one can see that, for example, in paragraph 49.
49?
Yes. So we see, for example, in relation to Essex Grove, that Fahana's evidence was she took out the mortgage on instructions from Mr. Khan. Her evidence was she received the renters to her bank account, carried out some administrative tasks in relation to the tenancies on behalf of Mr. Khan rather than for her own benefit, and Mr. Khan was the decision maker. So that's the sort of nature of control. We would phrase it as a form of administrative control. If one looks then at the skeleton argument, page 34, the appellant, what they attempt to do is build a platform based on what was said to be inconsistencies between Fahana's pre-action witness statement that was provided to Mohammed and her actual trial witness statement, and one sees that from paragraph 17.
The judge dealt with that.
Yes, exactly, and that's our point, lady, that paragraph 51 of the trial judgment, this is a point that was very squarely put at trial. It featured in the submissions and cross-examination, and then one sees paragraph 51 at the end. The emphasis is different, but I do not find there's any inconsistency, given she asserts the property was held for the benefit of her father during his lifetime. So, as a matter of fact, that notion that the property was held for Abdul pre-2005 has been rejected. We've looked already somewhat at paragraph 69, but I don't think I need to go any further in submitting that there are adequate findings of fact than to point to paragraph 69, because it's absolutely clear on the basis of the last sentence there. The trial judge says, I find on the balance of probabilities of common intentional acquisition of 7 Essex Grove, the creation of the leasehold and the transfer of freehold beneficial interest should be held on trust Mr. Khan during his lifetime and thereafter for the daughters. So we simply don't see where there is the inadequacy of finding of fact. It is worth noting that all of this was based on an array of evidence, and in particular, what was very important at the trial was the evidence of Mrs. Khan. Because as I've said, the way that the purchase of 7 Essex Grove came about was she was the joint owner of a flat at 64 Salford Road. That was sold. 7 Essex Grove was purchased in the name of Fahana. So her evidence as to the intention at the time of that original purchase in 1998 was quite important. One sees there, at paragraph 57, page 102, for bundle, the evidence that she gave. She said, third line down, her witness statement said, we registered 7 Essex Grove in the name of her eldest daughter, Fahana, on the understanding that 7 Essex Grove did not belong to her, but she was holding 7 Essex Grove for the benefit of all 3 of my daughters, Fahana, Salimi and Jennifer. It does then say that Mr. Khan was the decision maker, but in her oral evidence, she was consistent. She was saying, I was told that I'm buying it in the name of Fahana so that my 3 daughters can have it. And then the judge observes that I found Mrs. Khan to be a truthful and careful witness. So there couldn't really be better evidence that in 1998, one of the 2 putative settlors of the original trust of 7 Essex Grove came to court and said, this property is held on trust for the daughters. There was then other evidence from third parties such as Halim Khan, see that at 58, and another gentleman by the name of Mr. Udine, paragraph 54 is his evidence where he said, around the time of the divorce in 2005, he said, Mr. Khan told him, it is for my daughters, meaning 7 Essex Grove. So all the way along the fact pattern, there is very strong evidence in this case of a trust lying. Then we have the 2013 email and content of the WhatsApp messages. And the court has seen that the WhatsApp messages were held to be highly relevant evidence that the properties were held on trust. Now, I want to just deal briefly with one point which is just incorrect on the facts in Malone Friend's skeleton argument. Paragraph 23. So it said at the end of that paragraph, there should be page 36, sorry, of the court bundle. It said that it was significant, so the bottom of 36, it was significant, also significant, according to Fahana's own evidence, time was of the essence due to the claim of the divorce. Effectively, it needed to be clear within her divorce that she had no interest in 7 Essex Grove. And the suggestion seems to be that the transfer, the creation of the leaseholds, took place to ensure that. But that's simply wrong, we say, because if one looks at Muhammad's own witness statement, page 105 of the supplementary bundle, page 104, paragraph 105. It should be noted that Fahana and her husband had come to an agreement whereby Fahana would not make a claim on her matrimonial home and her husband would not make a claim on Essex Grove, so that substantial risk had disappeared. It could have stayed in Fahana's name, but my dad still wanted me to buy that property from him. He did not say I had to hold it on trust for him or my sisters, was what was asserted, but then, of course, the judge held differently. So it's not correct to say that this was transferred out of her ownership on account of the divorce, in that sense. So those are our submissions on ground 2, unless possibly any further assistance with that one.
Thank you.
Which brings us on then to grounds 3 and 4, which I'll take together because they really do mould into one at times. So there's really 2 headline points which are made by the appellant. Firstly, it's said that the De Bruyne type constructive trust is not pleaded adequately. And then secondly, it's said that the evidence in support of the De Bruyne type trust didn't meet the requisite threshold. On the pleadings, we would refer the court to paragraph 101 of the judgment. And this pertains to the point that Lord Justice Nugee made this morning, which was, well, to what extent was this raised at the trial? And what we did at the outset of the trial was produced a list of issues recorded there, paragraph 101, which were not formally agreed, but Mr. Lane, who was then for the defendant, did not object to them. And those issues included issues as to whether De Bruyne type trusts applied in relation to all 4 of the properties. In his skeleton argument for the trial and thereafter, Mohammed then fully engaged with the issues regarding the De Bruyne type trust. So there's no point taking in that document the effect that such a trust was not properly pleaded. So we ran the trial on the basis of the De Bruyne type trust argument. So we say that the appellant then effectively accepted that we were entitled to rely on those trusts in support of the claim. Thus, in any event, the particulars of claim made clear at the start, paragraph 1, this is page 130 of the core bundle. It says, pursuant to this claim, the claimants seek, together with other relief declarations, that they are beneficial owners of a number of properties pursuant to constructive trusts. So there is no limitation of the form of constructive trust to a common intention constructive trust. Then what we did was we set out from paragraphs 11 to 13 of the particulars of claim the relevant facts which we were relying on and which actually supported a De Bruyne type trust. We did the same in relation to Norbury Crescent at paragraph 22. We did the same in relation to Oldswater Road at paragraph 32. And then we did, and in relation to Essex Grove, now it was said that we didn't actually plead sufficiently the facts we were relying on here in support of a De Bruyne type trust. But one sees, should see some red text, and 6th line down.
Which paragraph, sorry?
Paragraph 47.
47.
So it's said in the 6th line down, the defendant, as pleaded above, took legal ownership of the 7 EG leaseholds again on the basis that he would hold them on trust for the 3rd to 5th claimants subject to Abdul's interest, which we say is sufficient for the purposes of what is needed for a De Bruyne type trust. And I should say that in Archbold and Alexander there was a similar pleading point taken. Ironically, I think against Mr. Lane, who was previously on the defendant's side in this case. And I'll come to that a little bit later because I'm going to come to Archbold and Alexander and show how it was dealt with in the case. So it wasn't necessary in our submission to give notice of the specific case law which we were relying on in support of a constructive trust claim. But we say, in any event, this was done in relation to 14 Stapleton Road, 53 Norbury Crescent, 5 Oldswater Road, in that section of the reply that we saw earlier. I should say the red words that we've just been looking at are an amendment. That amendment was made at the outset of the trial. If it had been indicated that there was any issue at that stage about whether it was sufficiently pleaded that a De Bruyne type constructive trust was relied upon, then certainly I would have taken that. I would have applied for permission to amend in relation to that.
Can I just ask a point about sequence? The list of issues was produced at what's called the beginning of the proceedings by the judge.
Yes.
And you said that the defendant engaged with each of those in his skeleton. Did he serve an opening skeleton?
Yes, he did. Yeah.
And did he engage with the De Bruyne type allegations there?
So, I have his skeleton, and what he said, paragraph 42, he said, alternatively, more recently, since the reply, a different strand of constructive trust is relied upon by C1 to C5, i.e. all the claimants, which does not require detrimental reliance, whereby property is placed into the hands of an individual voluntarily on the basis that it's for the benefit of another person. And I'm very happy to provide this document to the court. He then goes on to set out the relevant paragraphs which were included by the judge in De Bruyne and De Bruyne. So we say it was squarely within the compass of the issues that were being considered at the outset and during the trial, and the evidence was on the basis of those issues.
I think it would be helpful if you did provide us with a copy of that. Thank you.
So I come now to the substantive issues raised by Mohammed on the law as to the application of De Bruyne type trust. We tried to distill the points that are made against us in paragraph 43 of our skeleton argument. And what I propose to do is just deal with those in turn. So that's at page 68 of the core bundle. Now, the first point that's made is that Rochefort and De Bruyne are cases involving fraud and can be distinguished from this case. And then the next point is that it was suggested in my learned friend's skeleton argument that there must be a procurement of the property concerned by the constructive trustee, which comes about as a result of a clear promise intended to be binding that you hold the property on trust. I don't think either of these points were especially stressed in my learned friend's oral submissions, but I mean, I probably ought to deal with it anyway. And we just say that on the authorities, firstly, what fraud means is not actual fraud, it's just simply unconscionability. It's also been termed equitable fraud. Your Ladyship may have seen that in the De Bruyne decision. And then secondly, we don't quite understand what is meant by procurement, but if what is meant is that the trustee has to be the prime instigator of the arrangement, which was the case in De Bruyne, because he wrote a letter promising that the shares would be held for the children. We say, well, that's simply not a requirement on the law, looking at the case law. Then
it might be said that just entering into an agreement is, in a way, procuring an outcome, if you use that word. And that seems to be how it's looked at in some of the cases, if it's really a relevant concept at all.
Well, the widest formulation of the principle is actually in Rochefort itself, where what is said is, the question is, was the property conveyed to the trustee and as trustee? Did he know it was so conveyed? So it put as knowledge there. You know, I don't want to take things out of turn, but what I was intending to do was just go through the case law and set out what we understand the requirements of the De Bruyne type trust to be. 43.4, it suggested that, and I think this did feature in my own friend's submissions, that because 53 Norbury Crescent and 5 Old Water Road were purchased rather than transferred to the appellant, that excludes them from the ambit of the De Bruyne type trust. We say that's simply wrong in the authorities because you've got 3 cases at Court of Appeal level which show that a purchase can be the subject of a De Bruyne type trust. Those cases are Rochefort, Bannister and Bannister, and Neil and Willis. Neil and Willis perhaps being the starkest, as we'll come to see. And I'm just really making submissions in outline at the moment. But then he says the appellant's taken various actions in respect of the property, including entering into significant borrowing and so on and so forth. We say, well, that doesn't matter on the test, but in any event, 3 of these properties are properties in which he takes a 1/3 interest. So it's not surprising. And then he says constructive trust should not be imposed on in reliance on inferences from slender materials. We say, well, that's just simply not a case. This is not that case because we've got a whole host of oral and documentary evidence which backs up our position. So, starting with the point about actual fraud, we see how it's put in the grounds of appeal, paragraph 15. This is core bundle, page 19. So, yeah, ground 4 says at the end, such trusts have their basis in fraud. As such, the strongest of evidence needs to be adduced, and such evidence as was accepted by the trial judge did not pass the requisite standard. Then paragraph 35 of my friend's skeleton argument refers again to fraud. It's just important to see what the nature of the fraud actually is. Paragraph 34, there's reference to De Bruyne, third line down. De Bruyne is also a case of fraud, or a case which is tantamount to fraud. So, in terms of what's actually required, the most recent authority, as I say, is the National Iranian Oil case. And page 597 of the authorities bundle, we see paragraph 4, Lord Justice Zaccaroli's judgment, setting out what the issues are at this stage. This appeal also raises an important question as to the consequences of non-compliance with section 53(1)(b). Assuming that a declaration of trust has been made, but there's no sufficient evidence of it in writing, what is the status and effect, if any, of the declaration of trust? And that was ground 3 that one sees at page 599, so 18(3). Even if the judge was right to find there was no document which satisfied the requirements of 53(1)(b), he was wrong to find that the consequence was that NIAC and the fund could not rely on the trust which, on the judge's findings, had been declared. So, we see an important discussion of the width of the Rochefoucauld principle.
152 of
152 of the judgment, so it's page 626. So Lord Justice Zaccaroli says there, Rochefoucauld creates an important carve-out from the protection that section 7 afforded to the trustee in relation to a trust that's not sufficient evidence in writing. CGC accepts that it recognises an exception to the extent that such a trust is enforceable by the beneficiary if reliance on the statute would itself be in furtherance of a fraud. It contends, however, this has no application here because the principle derived from Rochefoucauld applies only where property is transferred to the trustee on the basis it will be held in trust for the beneficiary. It's termed a three-party case. So and one sees then that that's accepted as things stand in 153 by the appellants. So, and there's a reference then in 153 to the description of the three-party case in Rochefoucauld. It's a fraud on the part of a person to whom land is conveyed as a trustee, who knows it was so conveyed, to deny the trust and claim the land himself. It's been confirmed as limited to a three-party case in Canada and Australia. These cases explain that the reason the Rochefoucauld principle applies is because a person to whom land is conveyed as a trustee would not have received it but for the acceptance of the trust obligation. And equity considers it a fraud for that person to deny the trust and claim land as his own. So it's not that there's any actual fraud at the time at which the property is transferred. The fraud is for the person to later deny the trust and claim the land as its own, according to that analysis. And the bounds of this type of constructed trust are that you have to have what's termed a three-party case. You can't have a situation where someone is the legal and equitable owner of property and they declare, as was the case in NIOC, in the National Iranian Oil case, they can't declare that they hold on trust for another and then later when there's a transfer can a Rochefoucauld trust be relied upon. You have to have a three-party case. So this is of course part of the analysis of round 3 in which Lord Justice Zaccaroli was in the minority, but not on this point, because you see at paragraph 249, this is Lady Justice Falk's judgment, that's where she begins considering ground 3, and then 256, she agrees with the analysis in 152 and 153, which is what we've just been looking at.
Yes, and she just explains what you explained.
Yes, and then at 266, there is a significant explanation of what the equitable fraud, what equitable fraud actually means in this context. Because Lady Justice Falk says, before turning to Gardner Row, I should say a little bit more about Rochefoucauld and Balstead. I agree with the caveat of what I say in the immediately preceding paragraph. I agree with Lord Justice Zaccaroli's analysis of Rochefoucauld, but she elaborates a little bit further. The reason why the trust was enforced in Rochefoucauld was that it was regarded as an equitable fraud, or in modern parlance, unconscionable, for the defendant to receive property on the understanding it would be held on trust and then to deny the trust, reference then to Rochefoucauld and Archibald Alexander and De Bruyne. So what the requirement of fraud really just boils down to in the end is unconscionability in our submission. So we say it's certainly not a requirement of actual fraud. The Chancellor agreed with this at paragraph 283. I consider that Falk LJ has set out in her judgment a compelling analysis as to why ground 3 should be dismissed. So that's an agreement with that part of the judgment. Now, the point I would make in relation to all of this, what we've seen from Lord Justice Zaccaroli and Lady Justice Falk, is there is nothing which suggests that a procurement, in the sense of the trustee instigating it all, if that's what is meant, and as I say, I'm not totally clear on what is being said by the appellant, there's nothing which suggests that a procurement is required for a De Bruyne-type trust to apply. And one can see that, actually, as well, from the Archibald and Alexander decision, which is the next one going back in point of time. So, page 405 of the authorities bundle. So that was the case where, as we saw earlier, De Bruyne type trust was applied, albeit it wasn't, interestingly enough, the decision of His Honour Judge Gerald in the court below was not actually expressly by reference to De Bruyne or Rochefoucauld. But Mr. Justice Farringcourt nevertheless held that the decision was correct. Paragraphs 2 to 4 the key point about facts in this case is at paragraph 4, because you've got an agreement, as my own friend said earlier. You've got an agreement whereby the property is going to be held for mother for life, and after her death, the 3 children equally. But in 4, it said, in the event, although each of the 3 children could have become a joint registered proprietor of the house with mother, John and Brenda were unavailable to participate in the formalities when the house was purchased. So it was transferred into the names of mother and Patsy only. So it's just by sheer happenstance that you have 2 of the beneficiaries being unavailable to participate in the formalities. It's not as though Patsy is the one who instigates all of it and says, oh, this should be transferred into my name. Paragraph 28 contains a summary of the principle being applied. And one sees about midway down, there's a sentence beginning, the judge referred to no authority, but instinctively considered, in my view rightly, that if a property is transferred gratuitously to a person only on the basis of their agreement to hold it from trust for some other person, equity will not allow the transferee to rely on the absence of a formal deed of trust and keep the property for herself. Principle established in Rochefoucauld.
I'm not quite sure about this 3-party case stuff, because this is a case where one of the beneficiaries is the mother, and she's the one who pays for it all. And in another case, which is Bannister and Bannister, the claimant or plaintiff then transferred the property to the defendant, but for herself to have an interest in it. I mean, arguably in Rochefoucauld, it's actually the whatever she was, the countess, who procured the transaction for the property then to be held on trust for her. They're only. I know it was done by a mortgagee in that case, but the suggestion is that she was involved in the transaction and sort of brought it about.
Yes.
So I don't quite follow the 3-party thing. I mean, the difference seems to be that these cases are all about the circumstances of the acquisition, where someone does it accepts the property on the basis that he or she will then hold it on trust.
The distinction, as I understand it, and is that you're distinguishing between a scenario where you have a person who has full legal and beneficial ownership in property, and then declares that they hold on trust, as distinct from a scenario where you've got a transfer into the name of the trustee, and that criteria of full legal and beneficial ownership is not established from the beginning. If you have the point I think that is made in the National Iranian Oil if you allowed it in what Justice Zaccarelli calls self-declaration cases, where someone's entitled to everything, it would denude Section 53(1)b of all effect. So that's why you have that restriction as things stand.
Well, then you get the things like the common intent type constructive trust, but then it's a different sort of
because you have to show
constructive trust.
reliance and detriment.
But I suppose it's just a point about this description of as a three-party case, which I don't really understand, because I think most of these cases are actually, in reality, at least two-party cases. Because what's happening often is that someone is saying, I'll bring about the transfer, A is saying, I'll bring about the transfer of some property into B's name, as long as B agrees to hold it on trust, possibly for A themselves.
But I think,
and in fact, on the facts of some of the cases for A themselves.
I think a lot of the cases, the reason probably why it's termed three-party is because, and this we'll come onto this in ground 5, because the unusual element of it is that you've got beneficiaries who may not, as De Bruyne says, even know of the existence of the agreement. I think they are the third party. You've got party A who transfers it, party B who's the trustee, and party C who is the beneficiary. But I accept, Rod, that it's it may not in fact be entirely apposite as a title because of the I think the Bannister and Bannister case is probably the clearest, where you've only got...
Well, that's a two-party case.
Two parties.
A and B.
Yeah.
Yeah.
Anyway, there it is. I mean, it may just be that A is treated as C.
It doesn't affect us in this case, because in relation to all the properties, we've got transfer of property to Mohammed to hold on trust for others.
Yeah. But also for him, for Mr. Khan himself, for life, which is part of the reason why.
Yes.
I suppose it's not entirely apposite, because he gets a life interest on the judge's findings of fact.
Yes, he does. But you've always
and then the children, the other siblings all of the siblings, in fact, in various ways, get a beneficial interest.
You've always got people participating who are not A or B, if I can put it that way, because you've got Shalima, Jennifer, Saira, and Ahmed.
And so perhaps you would say the constituent parts are that the property is transferred to B, rather than you can't have a situation in which the owner, declares the trust and continues to hold,
yes,
goes to B, and then there are maybe a variety of beneficiaries, which may include A in some respect, but nevertheless will include others.
Yes.
Or might not.
The crucial element of it is the transfer to B.
It's the transfer to B. Okay.
But it doesn't have to come from A. It may be that A funds the transfer. So, for example, in this case we were just looking at, Mrs. Alexander the mother didn't actually own the house.
Yes.
She funded the purchase of the house, so it was bought on the market.
Yes.
So even the word transfer may be a bit,
yes,
maybe unnecessary. It's the acquisition of a property in circumstances where the defendant accepts it on the basis that he or she will be a trustee, it seems.
When my London Junior and I were dealing with the trial, we were trying to think of what a label would be for this type of constructive trust, and you could say it's a receipt-based constructive trust might be the way to
that can lead to other problems.
It's the only thing is then you get into
It might be an acquisition.
Other uses of
constructive
receipt,
trust.
Yeah.
Anyway.
Okay.
But nothing turns on that.
Thank you.
So, paragraph 32 of Archbold explains the difference between the different types of constructive trust. Rather than just reading all of that out, perhaps it's worth just looking
Yeah, we looked at that before.
Looked at it before.
So, on the pleading point,
Pleading point is
so paragraph 39. So I'm just talking about. I mentioned that in Archbold and Alexander, an issue was raised about whether a De Bruyne type trust had been pleaded. Paragraph 39. I mean, this was a case where the pleadings had not actually said we rely on a De Bruyne type trust. And in fact, the judge didn't even refer to De Bruyne or any other authorities. But you'll see what Mr. Justice Fancourt says there. It was originally a proprietary estoppel claim. Permission to amend is granted to bring in a constructive trust. And then in the course of the judgment, the judge moves from one type of constructive trust to another, but that process is not unfair to Patsy. And the point is made that unconscionability was at the centre of all this. Of course, that is just simply the case where you're dealing with constructive trust. The unifying principle of a common intention constructive trust, a De Bruyne type trust, is unconscionability. So we say that applies equally here. I want to go next to De Bruyne. Page 363, please, of the authority manual. So, paragraph 52. We accept, and this may be where the notion of procurement has come from in the other side's submissions, we accept that on the facts in that case, the husband procured the appointment in his favour of the shares by agreeing in a letter that would be held for the benefit of the grandchildren. But it's 51 which explains the principle, and we say that that does not contain any requirement of a procurement in the sense that we understand the appellant to be arguing. Because what it concentrates, looking down at the, I think it's the sixth line, these cases concentrate on the circumstances in which a transferee came to acquire the property in order to provide the justification for the imposition of a trust. And then it's presented as a line of, as part of a line of other authorities. Most obvious examples of secret trusts and mutual wills in which property is transferred by will pursuant to an agreement the transferee will hold property on trust for a third party. In neither case does the intended beneficiary rely in any sense on the agreement. He may not even be aware of it, but in both cases equity will regard it as against conscience for the owner of the property to deny the terms upon which he received it. We obviously rely on the next sentence. It's not necessary in such cases to show the property was acquired by actual fraud, although the principle would equally apply in such cases. This sets out then the test as enumerated in De Bruyne. The concept of fraud in equity is much wider and can extend to unconscionable or inequitable conduct in the form of a denial or refusal to carry out the agreement to hold the property for the benefit of the third party, which was the only basis upon which the property was transferred. And then the point is made it can apply to inter vivos transactions. So it's sufficient, therefore, on that basis, just for there to be an agreement to hold the property for the benefit of the third party, for that to be the basis upon which the property was transferred. Next case, Bannister and Bannister. We've discussed a little bit the facts of this case already. I'll just take the facts initially from the heading. So you've got the plaintiffs. Sorry, page number, page 46. The authorities. So we see on the plaintiff's oral undertaking that the defendant would be allowed to live in a cottage rent-free for as long as she desired. The defendant agreed to sell to him that as an adjacent cottage. The undertaking is not included in the formal conveyance. Then we see the plaintiff occupies the whole of the first cottage with the exception of one room which the defendant continues to occupy. There's an action for possession, and the plaintiff claims that she's just occupying as a tenant at will. The tenancy at will had been determined by notice to quit. The defendant counterclaims for a declaration that the plaintiff holds the cottage in trust for her life, and it's held that that created a life interest in favour of the defendant. So, worth noting, as I say, this involves a purchase of a property by the trustee. So that's relevant to the point that's said against us, that you can't have the application of a Rochefoucauld type trust in relation to a purchase.
I think he purchased this as a considerable undervalue.
Yes.
Yeah.
Yes, no, absolutely right. It's not a full open market value purchase. So the Court of Appeal judgment was given by Lord Justice Scott, and in the passage just after, can I just ask your lordships to read the passage just after letter B up to the end of that paragraph?
On which page?
We're on page 47.
From B. Okay.
Yes, from B up to the end of that paragraph.
You mean 47?
Yes, I do mean.
What's it
47.
about? The facts?
Yeah, just to see
Okay.
exactly how the conversation came about.
Yep.
So then, I'll just wait.
Yep.
Then in 48, we see the decision that was reached. So first instance in this case, it was held that constructive trust applied. And just before letter B, there's a sentence starting, in view of the learned county court judge's acceptance of the defendant's evidence, he necessarily found as a fact the oral agreement as a result of which the defendant conveyed numbers 30 and 31 for £250 included an undertaking by the plaintiff to permit the defendant to stay in number 30 for as long as she liked rent-free. That but for this undertaking, the defendant would not have sold the two cottages to the plaintiff at what, on the contradicted evidence of value, he rightly described as a bargain price. He further found as a fact there was no fraud in the case, so that's another nail in the coffin for the actual fraud argument. On these findings of fact, he held that on well-known equitable principles there was, as he put it, an implied or inferential trust, or in other words, a constructive trust number 30, under which the plaintiff held that property in trust for the defendant for life. Then it was attacked on, the conclusion was attacked on 3 grounds. You see in the next paragraph. Just after letter E, it said, thirdly, it was said that constructive trust in favour of the defendant, which the absence of writing admittedly would not defeat, could only be raised by findings to the effect that there was actual fraud on the part of the plaintiff, and that the property was sold and conveyed to him on the faith of an express oral declaration of trust, which it would be fraudulent in him to deny. And it said that the constructive trust conclusion couldn't stand. On 49, just above letter C, Lord Justice Scott says it is, we think, clearly a mistake to suppose that the equitable principle on which a constructive trust is raised against a person who insists on the absolute character of a conveyance to himself for the purposes of defeating a beneficial interest, which according to the true bargain was to belong to another, is confined to the cases in which the conveyance itself was fraudulently obtained. Then the point is made that the fraud which brings the principle into play is the setting of the absolute character of the conveyance. Later on, under letter D, nor is it in our opinion necessary that the bargain on which the absolute conveyance is made should include any express stipulation that the grantee is in so many words to hold as trustee. It's enough that the bargain should have included a stipulation under which some sufficiently defined beneficial interest in the property was to be taken by another. So the conclusion, later on under G, the conclusion that there was no fraud is immaterial. The Rochefoucauld itself paragraph, page 29 of the authorities bundle. We've got the facts of the case which really involve the contest being the owner of the estates which are subject to a mortgage. They're actually estates in Ceylon. And you've got a purchase at auction by the alleged trustee. And we see that on 30, first full paragraph, the case of the contest was that the purchase was made on her behalf, the arrangement with the Dutch company being carried on by the defendant alone after Duff's retirement. The defendant was a trustee for her subject to a charge in his favour in respect of all sums advanced by him in order to obtain the estates from the Dutch company, and of all sums which might be advanced by him to work the estates as coffee plantations. So again, it's a purchase. It's not merely a gratuitous transfer that takes place in this case. Page 37.
It's against indemnity, isn't it?
Yes.
So I think the facts were that the property was mortgaged. There was then going to be a sale by the mortgagee at just the right amount to clear off the mortgage.
Yes.
But that the purchase would be funded by the new mortgage, but that the Countess would indemnify Mr. Bousted against the obligations under the mortgage.
Yes, so I think it's
So
subject
it's a slightly
to a
unusual kind of
charge.
purchase.
Yes, it's quite an unusual purchase. It's referent in the passage I just read. It says it's subject to a charge. But her case was that it was subject to a charge in his favour that he received the property in respect of all sums advanced by him in order to obtain the estates, and of all sums which might be advanced by him to work the estates as coffee.
So there would be a charge over her beneficial interest, which is effectively an indemnity against all of his obligations under the new mortgage.
But he has, I mean, what's interesting about this one is that he has to lay out his own money at the start. And I say that because if you look at the end of that passage, there's reference to all sums. Well, perhaps it's not quite right to say he has to, but it's in contemplation that he might have to lay out sums himself in order to work the estates and coffee plantations. You see, that's what her case was from the end of that paragraph. That's the first full paragraph on 30. So unless there's anything further on that point, my Lord, the judgment of the Court of Appeal was given by Lord Justice Lindley in this case. And we see paragraph 37, page 37, first full paragraph. There was actually a decision against the contest on the first instance, deciding there was no trust. But then Lord Justice Lindley says, we've been unable to take the same view as the learned judge of the effect of the evidence would be necessary for us to deal with all the other defences relied upon by the defendant. Conclusion is reached then in the last full paragraph that the plaintiff has proved that the estates in question were conveyed to the defendant on trust for her, subject to a charge in his favour in respect of all sums advanced by him to obtain the estates and all sums advanced to work them as copy plantations. This conclusion renders it necessary to consider whether the statute of frauds affords a defence to the plaintiff's claim. Section relied upon is section 7, interpreting Forster, Hale, Smith and Matthews. Later, and so there's reference there to what is required if she was to prove an express trust under section 7, as it then was the statute of frauds. There's a sentence just beginning underneath Brewstead on page 38. It is further established by a series of cases, the propriety of which cannot now be questioned, that the statute of frauds does not prevent the proof of a fraud, and it's a fraud on the part of the person to whom land is conveyed as a trustee. This is the passage I was referencing earlier, and knows it was so conveyed to deny the trust and claim the land himself. It is interesting there, it's put just in terms of conveyance as trust to someone as trustee, and that person knowing that they are trustee. So again, tracing all of this back, there's no requirement of actual fraud. The fraud is denying the trust and claiming the land yourself. And there's no reference either to any sort of procurement. The simple question posed here is, well, was the land conveyed to the person as trustee, and did he know it was so conveyed? We would say that, perhaps this is an opportune moment to deal with the common understanding point. I mean, we say that the finding of fact by the judge, looking at the judgment, it was by reference to the issues as were posed. And so perhaps I could just refer you to page 111 of the core bundle and paragraph 108 of the judgment. So that should be issue 4. And the question that was posed there in relation to Essex Grove was, did the defendant acquire the leasehold interests, either subject to an existing trust or according to a prior agreement that the daughters would have equal beneficial shares in them, subject to Abdul's rights during his lifetime? The judge answers 109, and consider there's ample material to support the existence of a De Bruyne type constructive trust. Then in relation to, it's the same in relation to the other properties. Issue 7, paragraph 115, Stapleton Road. Did the defendant acquire Stapleton Road according to a prior agreement? Some should have equal beneficial ownership, subject to Mr. Khan's rights during his lifetime. 116, I find that the defendant did so acquire 14 Stapleton Road. Norbury Crescent is the same at 121 and 122. And then Allswater is at 125 and 126. So we say that this notion that all the judge found was a common understanding is simply wrong. Looking at the findings of fact, the judge found that there was a prior agreement which resulted in the transfer of the relevant properties. But we say anyway, in echo of what Lord Justice Miles said this morning, that where she does refer to a common understanding, there's no difference intended between that and what is later set out in the key passages at the end of the judgment. So I can just take a moment just seeing where I've got to. One final case to go to on this area is Neal and Willis. Just because it, in our submission, demonstrates the width of the Rochefort principle. So page 51 of the authorities bundle is so it's another decision of the Court of Appeal, and I'll just take the facts again from the head note. So really, this case was about a purchase by a husband where one sees about a third of the way down where the facts are. In 1961, the husband was informed that a house was available for £2,820, for which the council were prepared to advance £2,770 on mortgage, leaving £50 and about £100 for legal expenses to be found in cash. £100 met from money received from the incoming tenant of the flat husband and wife had been in before. Husband and wife agree to put the house in joint names. The husband borrows £50 from his mother-in-law to complete the purchase, telling her on her inquiry that the house was going to be in joint names. And then you've got a further £10 that comes from the wife's bank account, but the house is conveyed in the husband's name. There's a separation of divorce 1964, and what's important to note is that the court's just considering this on equitable principles. This is not in the family court or anything like that. So it's only 50, for present purposes, the key point is there's only £50 worth of the purchase price of 2,820, which is received from the mother-in-law. But the agreement with the mother-in-law that the property would be held on trust is enough for the court to impose constructive trust. And page 53, one sees the nature of the agreement reached. So second full paragraph on that page. In addition, they needed the £50 to pay the council, but they had not got it. The husband borrowed it from the wife's mother, Mrs. Getting. He asked her for the £50. She said to him, "Is it going to be in joint? Is it to be in joint names?" He said, "Yes, it is going to be in joint names. Look, here is the application form which I've signed." Showed his mother-in-law the application form with the two names on it. Thereupon, she made a loan to him for £50 on the express undertaking that the house was to be in joint names. We see towards the bottom of 53, the last paragraph, it says, fifth line down, instead she took out an originating summons. She didn't make an application under section 17 of the Married Women's Property Act 1882 as it then was. Instead she took out an originating summons in Chancery to decide the titles of the house. The husband claimed it was his, the wife said she was entitled to half interest. The judge applying the principle of equity held that the husband held the house on trust for his wife. and then you see the conclusion reached by the judge there, to the effect at the end equity would compel him to hold any interest in the land which he acquired in the contract and trust for himself and his wife. There's then submitted by the husband that that statement was wrong, and Lord Denning says, I think the judge was quite right. And the key passage is about halfway down the page. There's a distinction of Bezic and Bezic, and then it said, I'm not impressed by this distinction. It was a binding contract and a court of equity would not allow the husband to go back on it. It would enforce it by holding the husband holds the property on a constructive trust for himself and his wife. That follows from Bannister and Bannister. That case shows that if a person who takes a conveyance to himself, which is absolute in form, nevertheless has made a bargain that he will give a beneficial interest to another, he will be held to be a constructive trustee for it for the other. He cannot insist on the absolute character of a conveyance to himself for the purpose of defeating a beneficial interest, which according to the true bargain is to belong to another. And Lord Justice Diplock agrees with that and agrees that the principle, this is later on down at 55, the principles in Bannister and Bannister should apply. So clearly, again, this is another case where it makes clear that you can have a purchase, a De Bruyne type trust can apply. It also makes clear that the trust obligation can be imposed even where it's only a small part of the purchase price that's transferred on the basis of the agreement for the property on trust. And so we say that that's relevant to the final, one of the points that's made by Mohammed, which is that in holding the properties in his name, he's taken various actions, including taking on significant borrowing. He says he's used his own funds in relation to them. He says he's developed the properties. And we say there's simply no grounds here for this to affect the imposition of a De Bruyne type trust. It's clear enough that in a number of cases, money has been put up by the constructive trustee as part of the bargain. That's the case of Rochefoucauld, in Bannister and in Neal, but nevertheless the trusts were imposed by the court. And in any event, none of this is really a surprise, because in relation to 14 Stapleton Road, 53 Norbury Crescent and 5 Oldswater Road, it's been our case all along that Mohammed has a 1/3 interest in those properties. So it's unsurprising that he's been willing to take on borrowing less time into those properties. It is suggested in my friend Skelet's argument that, I can't remember actually if it's the Skeleton argument or grounds of appeal, that Mohammed has put in his own funds. What is important to note is that there's no finding by the trial judge to that effect, and my clients do not accept that. And finally, there's mention by Mohammed of developing 53 Norbury Crescent as a nursery business. You would have seen in the judgment that there's reference to that being held up by a separate company from which, in which Mohammed has an interest and clearly benefited from that. So again, it's not surprising that he's developed it in that way. So therefore, in light of these submissions, we say that ground 4 should be dismissed. And unless I can be of any further assistance on that, I move on to ground 5.
Right, please do.
So, ground 5, we get into the world of common intention constructive trusts, and of course these were, in the end, alternative claims in relation to all the properties, because it's in relation to common intention constructive trusts that we have to prove detriment, or at least subject to the point made in the respondent's notice. Now, there was reference to Fahana's position, and I want to just deal with that first of all, because Mohammed made an application for the amendment to grounds of appeal and to his skeleton argument. certainly we do not object to the parts of those documents which strike out the points that Ahmed suffered detriment. And the significance of all of that is that in relation to Stapleton Road, Norbury Crescent and Oldswater Road, we're now in the position where Ahmed has succeeded on any view in our submission. The reason we were not willing to consent to the amendment of the grounds of appeal is because it still maintained that Fahana did not suffer sufficient detriment for the purposes of the common intention constructive trust claim over Essex Grove.
Do you mind if I just ask a question before you
Yes, my lord.
deal with that? Just on the first point you make, that Ahmed has succeeded, does that, would that mean he gets 50% or 33%?
Well, it's that, in my submission, illuminates the issue before the court in relation to the respondent's notice. Because if it's the case that the court is only will only enforce the trust in favour of a party who has proved detriment, but not in favour of other claimants who have not proved detriment, one enters into quite a difficult world.
Sorry, I wasn't really meaning to get into the substance of the argument.
No.
What I was really getting at was, does the defendant accept, on that basis, a 50-50 split, or does the defendant say he gets 2/3 and Ahmed gets 1/3? Is that where things stand?
It is.
Right, okay.
And just for clarity, I mean,
I know you're going to come on to the point, but...
to actually answer your question, Lord, it's not a straightforward analysis, but I think what we would say is, in that world, you're in a world where, so if Sawa does not succeed, you're in a world where what the common intention was that the brothers should have equal shares. And so you can't
Equal 1/3 shares.
Well, indeed, but you're proceeding on a counterfactual where you're not, and this is what we say the problem is, because we say what the court has got to do is apply the common intention. What the case law says in relation to common intention and constructive trust is that is the role that the court has, where there's an express common intention, it implements that. If that's not implemented by virtue of just one party not having incurred detriment, you enter into a bit of a fantasy land, really, where you're not any longer applying the express common intention. But insofar as we get into that territory, we would say that it can't be right for Mohammed to say that he should have 2/3 when on any view that was never intended. And the nearest the court can get to it is this was an agreement that there should be equal shares and it should be 50-50. Returning to Fahana, we say that the argument that she did not suffer sufficient detriment, we say that that's a matter on which permission to appeal was refused. And the starting point on this is to look at the original grounds of appeal. I'm hoping that your lordships have Mohammed's application bundle. And I'm looking at page 20 in particular.
Page 20?
Yes. So I'm operating electronically here. I have a bookmark saying this is the permission to appeal amended grounds of appeal from the 13th of December 2024.
Amended grounds of appeal beginning at page 13.
Yes, so paragraph 20, page 20, paragraph 21.
At bottom of
Ground
page, ground
11.
11.
Yes. So ground 11, it stated there that there was no basis on which the trial judge could find that the first and fourth respondents acted to their detriment, such that a common intention, constructive trust should be imposed. There's then what we've called the legal point, which is the point that we're considering under the respondent's notice.
Yeah.
Under A and B, it then reverts back to the point about sufficient detriment, and B is in relation to Fahana, so that seems to be connected with the first bit of 21, and it said various arguments made there about whether she suffered detrimental violence. So we say that the issue of whether Fahana established detrimental reliance for the common intention constructive trust claim is put squarely before the court at that stage. It's said in the middle of that, or towards the end of that paragraph, that what she did in relation to her divorce could not be argued as detrimental reliance. Then could I turn please back to the core bundle and the permission to appeal order. Lord Justice Zaccaroli's order. Page
Yes.
2, round 11, so right at the bottom of page 2, the point made in the grounds of appeal is that there was no basis on which the judge could find that the first and fourth respondents established detrimental reliance. And then there's a reference to the other point made, what I call the legal point, to the point of law to the effect that there was no requirement of detrimental reliance. If the judge held there was no requirement of detrimental reliance, she was wrong to do so. Permission is granted on that. But then Lord Justice Zaccaroli says, I refuse permission, however, insofar as the points made in the grounds of appeal are maintained. These are appeals against findings of fact, and various reasons are given. So we say, therefore, that is the end of the road for Muhammad, and that permission is being refused in relation to the issue of whether Fahana suffered detrimental reliance, and that therefore, on any view, she should be considered to have succeeded in relation to Essex Grove.
That doesn't seem to be making it doesn't make the sort of compensation point about the other property, which is Middlesex Road.
No, it does. Lord, you're quite right. But do you mean the permission to appeal order or the grounds?
Well, I was looking at the grounds of appeal, and then the judge says, Lord Justice Zaccaroli says, well, you can't appeal on the factual findings, and the point that was made there was that essentially there wasn't enough evidence.
Well,
but nothing is said about this sort of compensatory benefit point. So how have they brought that in?
Well,
or sought to bring it in?
It's a good question, Lord. I mean, the point I would make for present purposes.
So is this right, that by amending it, they've actually changed it?
Well, I don't think it's quite as stark as that, because I think I'm right in saying, I'd have to check, I think I'm right in saying that points about Middlesex Road were raised in the original skeleton argument.
Page 41. Page 41 of the application bundle, paragraph 57.
Yes.
Despite having set out that issue, which was Middlesex Road, the judge simply failed to deal with it at all. She could not have found it. See in the round about taking into account that issue.
So I certainly don't say that they have introduced that as part of the amendment when it wasn't originally put in the skeleton argument. It wasn't contained in the grounds of appeal.
But how was that tied into the ground of appeal that we've just looked at?
Well, it is in my submission, because looking at 20 of their application bundle, one has to look at the first sentence, which is, that is the headline ground of appeal, if I can put it this way. There was no basis on which the trial judge could find that the first and fourth respondents acted to their detriment such that a common intention of constructive trust should be opposed. And we would say that that captures, that is a broad allegation that the trial judge was wrong to find that Bahana suffered detrimental reliance. And then we say that what has happened in the permission order, Lord Justice Zaccaroli has refused permission on that.
Because it's all bound up with these are appeals against findings of fact.
Yeah, but we say because when you go back to the reasons under ground 11, it said at the top of 3, second line, I refuse permission, however, insofar as the points made in the grounds of appeal are maintained. And then the material that Lord Justice Zaccaroli had to work with, in terms of what was in the grounds of appeal, is what is then referred to in the reasons thereafter. So the allegation and the evidence is remarkably thin, unsupported by documentary disclosure, etc. If, for any reason, I'm wrong about that reading of that order, I do have submissions on detriment as well, and what I would say first of all is that it is necessary to look carefully.
Well, before you go on, where are you in the scheme of things? Because it's gone 4:15. You've got to deal with your alternative submissions
Yes.
in this regard, and then there are 1 or 2 outstanding grounds of appeal which aren't terribly long, I don't think, and then there's your respondent's notice.
That is your response notice. Yes.
Well, we have until 1 o'clock tomorrow,
Yes.
so I think it's probably appropriate to arise now, and please agree between yourselves how you're going to divide up the rest of the time.
We will.
Thank you very much.